I'll watch that. I'm ready to begin the question.
Yes, sir. I'm standing in for Ms. Dudley today. Your Honor.
Okay.
And Your Honor, this is Jaron Carson, 22CF 1778, and there is a written plea agreement, if I may approach her.
You may.
Yes, Your Honor. At this time, Mr. Carson would admit to the violation of probation with the understanding that the withhold of adjudication will be maintained. Probation will be modified to include 12 months of drug offender probation with a, I believe it was 10 p.m. to 7 a.m. curfew.
Correct.
And a $100 DOT fee. Your Honor, I'm not sure how Mr. Carson's work schedule, but obviously working with that schedule, we would ask for some leeway to coordinate.
That's always available. So, yeah, I don't think it needs to be included in there. Mr. Carson, would you raise your right hand, please? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Yes, sir. Okay, so you just want to make sure you've talked with your attorney about this plea agreement, because you're waiving the right to contest this and have a hearing, and this will be a resolution of your violation of probation. Do you understand that?
Yes, sir.
So have you read this plea agreement?
Yes, sir.
You've had all your legal questions answered either by Mr. Durrell or Ms. Dudley before?
Yes, sir.
Okay. Very good. Based upon that, the court will accept your plea. The court will maintain, say it's okay, obviously, with this.
Yes, Your Honor, this is a state's agreement.
So, the court will maintain the withhold adjudication, assess the defendant a $100 BOP fine, reinstate probation, complete all the original requirements. The only change is for the next 12 months, the defendant will be on drug offender probation. So there's some additional requirements. You understand all that?
Yes, sir.
Okay. And there'll be a curfew on that from 9 p.m. to 7 a.m. Okay? Any questions? Okay. Thank you very much.
Very good.
Thank you, Your Honor. That's all I have.
Thank you, Mr. Durrell.
Right there.
Garrett.
Good morning, Your Honor.
Good morning, Mr. Garrett.
Your Honor, I'm here on behalf of Lewis Hall, Chris Garrett on behalf of Lewis Hall, 20 CF 525. Your Honor, we thought we had a resolution worked out today. We do not. We would enter a denial, and if we could, Mr. Hall has a new law violation, 23 CF 1018. Would it be possible for this case just to travel with that, or is it going to stay?
What is the related case?
23 CF 1018.
It's on your 814 regional conference because it's a new case.
Sure.
The case number is 23 CF 1018. It does have Mr. Garrett on there.
Okay, so we can track it with the pre-trial. So we'll continue this case. Well, actually, you need to make a plea. Are you entering a plea of the denial?
Yes, Your Honor, we're entering a denial.
So court will enter the denial, and we'll come back, we'll track with the other case on it's on 8/14. Actually, both of these cases should be 8/16 because it's within minutes. So August 16th and 19th.
Thank you, Your Honor.
Thank you.
And Your Honor, I have today on the docket, we're scheduled for a motion hearing on behalf of Lita Gaitan, 22 CF 3047. Good state.
Wait, help me out. Who's the attorney on this?
Chris Garrett, Your Honor.
I know, but I don't have you on this.
Your Honor, he's referring to a case that's set for 2:30 this afternoon.
Yes, Your Honor, for
The state
suppression
will
hearing.
be
Different doc.
Yes,
Okay.
sir.
The state will be announcing a no cross in this case, and I'll get that paperwork filed today.
Okay, so we'll just deal with that this afternoon, and you'll you can go tomorrow.
Maria, Gaita. That's a 240.
So it's on the 230 docket? Gotcha, very good. So the state's announcing no cross on
No cross.
22 CF 3047?
That's correct.
Very good. You do not have to come back this afternoon.
Sounds good, Your Honor.
Thank you, Your Honor.
Thank you. Mr. Cotton?
Good morning, Your Honor.
Good morning.
You know, for the record, Byron Cotton with me on behalf of Gabriel Spencer. Judge, we've reached an agreement on this case. I have a plea agreement and a score sheet if I may approach.
You may. Thank you.
Yes.
Would you please announce the agreement?
Judge, I'm sorry I gave you the terms. I don't mind doing it. Thank you. That is a shot. Judge, pursuant to an agreement with the state, case number 2016 CF002350, in violation of probation, parties have agreed to a sentence to be as follows: that Mr. Spencer would admit the violation, he be adjudicated guilty, that his supervision would be modified as follows. He's going to spend the next 2 years of supervision on drug offender probation, followed by the balance of probation on regular probation. Curfew during the drug offender probation is 7 p.m. to 7 a.m. However, it may be modified by probation to accommodate a work schedule. Curfew during the balance of probation is to be from 10 p.m. to 6 a.m., which also may...
That's just the standard.
Well, on drug offender...
On the regular probation, is that the...
There is no curfew on standard probation, Judge.
Regular probation has no curfew? No.
So, but by agreement, we've agreed
Sure.
that it'll be 10 p.m. to 6 a.m., but it also may be modified by probation for work schedule. He is to complete DUI school and any recommended treatment concurrent with a DUI case, which is the subject of violation. That has not been, I'm handling that in county court separately, just so the court's aware. However, he is going to be required as part of this to complete that regardless of the outcome of that case.
Okay.
Probation, we originally had an auto terminate. It is not going to automatically terminate at 50% of the sentence, and it reinstates all of the prior requirements.
Very good.
Those were all the terms, Judge. May I reapproach?
Yes. I'm going to ask you one clarifying question, but
Yes.
then it's going to see how it's written.
Yes.
No, that's sorry.
Mr. Cotton, would you pass in the score sheet?
I did. It's attached. Thank you.
Okay, so just a point of clarification. I think I understand it the way it's drafted, but I want to make sure it's clear for your client's
Yes.
benefit. So the 2 years probation to be served as drug offender probation, based upon the way it's written here, it does not add any 2 years onto it. It's just the probation, you've got a certain probation, whatever that is. The next 2 years are going to be drug offender, the remaining time is going to be regular probation.
That's accurate.
Just want to make sure that's clear.
Yeah. So he's got 6 years left.
Okay, no, I just wanted to make sure, because if it was added on, I wanted him to make sure he was clear, because
Thank you for
anyway, we
clarification.
always want to be clear. So
Yes,
anyway,
sir.
would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
I do.
Okay, and the state's in agreement on this?
We are, Your Honor. It is a downward departure.
Okay, and what's the basis of the downward departure?
Well, Judge, I did it as a modification. However, it'd be based on as opposed to, it was already a downward departure. So I did it as a modification of the sentence.
So
However,
it's a
it is a
modification,
continued
doesn't
downward
require
departure based
any
on
additional findings.
That's correct, Judge.
Okay,
But it is by agreement with the state.
okay, very good.
Thank you.
So, Mr. Spencer, you heard your attorney state the terms of the plea agreement, and I see that Those same terms are contained in the written plea agreement, violation of probation plea agreement. Have you read this agreement closely?
Yes, sir.
And have you gone over it in detail to make sure you're, had all your legal questions answered?
Yes, Your Honor.
And you understand that by entering into this plea agreement here today, you're waiving the right to go to a trial to contest all
Yes,
this
Your Honor.
on the violation. You believe this is in your best interest to do
Yes,
this?
Your Honor.
Okay. And you've had all your legal questions answered?
Yes, Your Honor.
Okay, very good. Based upon that, the court will accept your plea agreement, and the court will accept the admission and the adjudication. There will be, the next 2 years will be a modification of your probation to have drug offender probation for the next 2 years, then followed by your regular probation. We've got some curfews that you need to abide by, and the other items, the community service, the DUI school, etc. And you're not able to automatically terminate. The way I read that, it still would be a possible option, but it's not mandatory.
That would be between the state and the court at a later date if that were to go.
Okay, very good. And reinstate all prior requirements. Okay, any questions, sir?
No, Your Honor.
Thank you very much.
Are you charging $100?
Yes. It'll be $100 BOP. And you do have, even though you're agreeing to this, it's a new sentence, you do have 30 days to appeal it.
Yes, Your Honor.
Thank you very much.
You should be up to date. Your Honor, the next case I have is for Brad Stewart. This should be Mr. Bennett, is that accurate? Okay. Your Honor, pursuant, Mr. Stewart asked me to handle his case for him today as he had been in the court. And he is asked to set that for an evidentiary hearing. I believe that has been discussed with Assistant State Attorney Taylor Sharpless.
So I assume you're entering a denial, but I don't think there's been a plea, so we'll accept a denial.
At this point, based on his, if he wants an evidentiary hearing, I would assume so.
I'm just putting it on the record.
Yes, sir, thank you.
And how long do you anticipate the evidentiary hearing need? Just so we can schedule it. Does he want to schedule it now?
I think he would probably like to go ahead and set it, and I assume that's going to be in an afternoon document. Is that how
Yes.
this report?
Yeah.
May I have a moment?
Sure.
It's not a 20-minute now. I'm just going straight to 18.
Good afternoon.
Sure.
I think he really gets an extra
Your Honor? Oh, I'm sorry, let me just interrupt.
That's all right. I'm sorry, Ms. Moss.
July 18th at 2:30.
Okay. Go ahead.
Yes, Your Honor, it's my understanding after it's been discussed with me, this is a technical violation. I would imagine on a technical violation based on what I've been told and after consultation with the state, an hour with max would be needed,
Okay.
so is that?
So-
Okay.
So we'll schedule the evidentiary hearing on July 18th at 2:30. Does that work all right, Ms. Sanders?
That works, Your
I
Honor.
know
Just-
you're filling in. but-
I'm filling in, but just for the record, we would revoke any offers since this is a set for hearing. I think an offer's already been sent over to Mr.
If there's any offers that were made previously on this issue, on the VOP being withdrawn today.
May I?
Sure. Just for the record, what are the offers that are on the table? I know I'm putting you on the spot, but.
And we're paperless, so if you'll give me a moment, Your Honor,
Okay.
I'll look it up. We'll reserve, Your Honor. We won't withdraw that today. The defendant's making representation that he hasn't received an offer. So we'd like Mr. Stewart to have the opportunity to talk to him, but just for the record, he does score prison 26.7 months.
Okay. Very good. Thank
That
you.
addresses that issue, since there's No offers being revoked, so I don't think we have to do it.
Okay, so we're scheduled for July 18th at 2:30.
That's fine. Thank you, Judge.
Thank you.
Your Honor, that's all I have for the
Okay,
court.
thank you.
Thank you.
Appreciate it. Have a good day.
Yes, sir, you as well.
Mr. Patel? You hiding back there?
Good morning, Judge. I'm also covering for Mr. Stephen Willis, his client. Can I take that one first?
Yeah.
His client is Sonny Preston Wood, who's present and approaching.
Sure.
And Judge, based upon my conversation with Mr. Willis, he indicates that he and the state are still negotiating and asked that this case be continued. I don't believe there's any objection.
Okay. Do we want to put it on a pretrial or put it on another miscellaneous day? Who's handling this for the state?
Your Honor, that would be great if we could go ahead and set it on pre-trial.
On pretrial. Pardon?
There's no new law.
We can put it on
Okay.
pretrial.
How far out is pre-trial, Your Honor?
Pretrial is 8/16.
All right, thank you.
Is that too far out?
I think that's plenty of time. They sent me reciprocal discovery that I need to review.
Okay. Okay, so we'll come back on 8/16, excuse me, 8/14 at 9 a.m. Okay?
We can get you notice, and then make sure you get in touch with Mr. Willis.
We don't need to know.
Oh, never mind.
No, I'm sure the clerk can handle something.
Mr. Wood? Mr. Wood?
We'll notify his attorney.
Just make sure you talk to your lawyer. Make sure you talk to your lawyer.
Are there no notices if they can?
There's some up there if you want to write something.
It's okay. I'll leave this. Next, Judge Jay Patel on behalf of Bradley Dunham, 21 CF 1573. Couple issues we need to lay out that makes me feel uncomfortable. If you recall, we did a sentencing, and at that sentencing, I made an objection relating to the mandatory
Before we, is your client?
No, he's in jail, he's in prison,
Okay.
which is good.
Okay, go ahead, go ahead.
Okay. So, if you recall, Judge, you reserved ruling on the mandatory GPS application.
Yes.
You asked us to supplement the record, and then after each side supplemented the record, then notice it for hearing.
Right.
Which is why we're here today.
Right.
A couple days ago, my client filed a pro se notice of appeal for indigency. I was not copied on that, so when I was preparing for this hearing, I saw that. Other problem. There was a judgment and sentence that was issued. My belief is that your judgment is not complete because you still reserve ruling on an issue relating to sentencing.
Right.
So I'm not sure that it's appropriate, and then there's been no orders appointing a public defender or things of that nature. So I don't want to
You're talking about for the appeal or for
the
this?
appeal.
For this?
So I don't want to be put in a position where I'm talking on behalf of Mr. Dunham when I shouldn't be talking on behalf of Mr.
I
Dunham.
understand.
I don't know what the court's feeling is, but maybe the court needs to order Mr. Dunham, DOC, to produce Mr. Dunham back to Okaloosa County so that we can figure this out.
Mhm. Who's handling this for the state?
I am, Your Honor. Certainly, we would leave that at the court's discretion as to whether or not Mr. Patel can speak on his behalf, but we certainly understand his concerns, and we actually believe that Mr. Dunham should be present with us.
That would overcome any issue of lack of clarity as to whether he wants you as an attorney or whether a new attorney should take over. If there is a new attorney on the appeal, and
That's right. My number one
there can
concern.
be a little bit, I want to say, confusing, but maybe some.
Several hurdles, but the first and most important one is me having the ability to advocate on his behalf.
Sure. And you mean having him present in order to do that?
Just so it can be clear on the record.
I don't disagree. I'm surprised we didn't address that in advance of this hearing.
I didn't, to be honest, Judge, I didn't know that.
It's not something I would normally like look through it and say, yes, he does. But I agree with you. He needs to be here.
Yeah,
It's kind of fundamental, particularly when you're dealing with, I think sentencing is required to be here.
Well, and I think that I'm presuming the state would agree with me that the judgment and sentence should not have been issued yet because it's not complete.
I agree. Without the state giving you the opportunity, do you disagree?
We
If
agree
we
that it should
reserve-
not have been issued yet because you reserved us that one issue.
Yeah.
So we agree it should not have been issued yet.
Yes, we should have.
There wasn't another court date provided. I have the minute sheet, there was no court date given.
That's correct, but what, you know, for the record, nobody, you know, I mean, I'm not, nobody's upset, we're just trying to make sure defendants' rights are properly protected. There was a reservation at the time, so I'm just kind of, I'm not going to keep rolling that I'm stating, so there was a reservation at the time, and we should have waited until after we had this final hearing. Because it's a hearing basically on the sentencing.
That's right.
That's the final. And I have read it. I think it's a shame, you know, I mean, I don't think it's a complicated, well, it could be, it's an interesting argument, but it's not something that's lengthy in the sense of probably requiring a lot of witnesses and so. So let's continue this hearing. And so what do we need to do on the sentence that has been entered?
Because he was remanded. He came in of his own accord and he was taken out the side door.
Well, I understand that. And he should have been remanded. I would have remanded him and held him until.
And to be clear, just for the record, Your Honor, the only reservation was as to the GPS on the probation to follow and a lengthy DOC time. So he was going.
That's fine. I mean, it's not that he would have been released or anything like that in the interim. So, just a technical.
What I propose is we probably set this case, set a new date out about 45 days. I send over a proposed order to transport and we get him here and we address all these matters.
I agree.
State agrees, Your Honor.
Okay.
So that means.
What do we got about 45 days out? Let's see, that's a problem because we've got a July 18th, which is about a month out, and then the next miscellaneous isn't until August 17th, so I guess we just need to do the August 17th.
That would be the state's request, Your Honor.
And we'll do that in the afternoon again, 2:30. Would it be 2:30? Yeah. 2:30.
Is it possible to have it in the morning, Judge? Because I have a hearing on a homicide case that afternoon.
It really shouldn't be a long hearing once we determine if Mr. Dunham wants Mr. Patel to speak on his behalf. I believe the court has pretty much the brief.
So do you anticipate just making arguments on your brief?
Yes.
Okay, I agree.
I may have some input from probation parole, but
No,
that
I
would not be.
understand. I just want to make sure, you know, I mean, in theory, I can see a world in which somebody wanted to have a witness or something, but, you know, if you all are telling me we're not going to have any witnesses and it can be done, it will be done in 15 minutes.
I'm already in case law.
Yeah, you give me and I'll review it. I mean, I want you to argue it, but I'll review it.
Would you like this hearing to be called?
Just
Sentencing.
Another sentencing?
I believe if you want to label it, I think sentencing would probably be most appropriate.
I'm sorry, what was that date again, that short-term memory thing?
It's all right. It's August 17th at 9 a.m.
Thank you.
Thank you, Judge. I have nothing further. I'll go over this afternoon.
Thank Thank you very much.
I don't think, at this point, I don't think I need to do a proposed motion, or a motion. Do you?
A motion on what?
To order, or are you just good with something, or are you just good with an order for transport?
I need, yes. I thought you said you were gonna give me an order to transfer.
And do I need to file a motion, or is this
Oh,
conversation good?
I don't think a motion is required, but just an order, just something to memorialize. The motion was made for a tense. Yeah,
Thank you, Judge.
Just an order. I appreciate, I assume that.
Thank you, Judge.
Thank you. Have a good day.
You too.
Okay. We have a couple from Mr. Harper. You want to, we've got a few that don't have attorneys.
I had one inmate that doesn't have an attorney.
Let's go ahead and get folks here who don't have attorneys. Who's the inmate without an attorney is Daniel Ask. If I pronounce that correctly.
Ready for Daniel Ask.
And then we'll do yours, Mr. Harper.
Hey, Mr. Ask, you can make your way to the lectern.
Good morning, Mr. Ask. Would the state will identify the case?
Your Honor, this is Daniel Ask. He's here on 19 C. I'm sorry? Askew. Thank you for correcting me. This is Daniel Askew. He's here on 19 CF 3282 violation of probation. Right now, the state's offers an admission, adjudication of guilt, revoke and terminate for a new term of 18 months, community control, $100 violation probation fee, and public defender fee.
Okay. So, Mr. Askew, you do have a right, so you've been charged with a violation of probation, right? You understand that?
Yes.
That's why you're here. So you do have a right to have an attorney, okay? And the court will appoint an attorney for the state. If you wish, I'll have Ms. Sanders slow down and say that again slower. If you want to consider a plea agreement without talking to your attorney, or I'll just appoint you an attorney here today and you can talk to your attorney and that plea agreement will remain open as well. So, do you wish to have an attorney appointed, or you want her to say the plea agreement?
I had wrote one of those applications.
An application for an attorney?
Yes.
Okay. So you wish to have an attorney appointed?
They never got back with me.
Okay, well, I'm here.
Your Honor, I was pulling while we're sitting here. We did have the public defender appointed in 23 CT 1195. The clerk appointed our office. He was found indigent on June, I want to say the 10th. So with a recent application, the court could just go ahead and appoint the PD's office and not leave him to fill it out.
Okay. Very good. Court will appoint the public defender.
Mr. Medina, I would ask to keep him. It sounds like this may be something he could take today, basically put him back on supervision. And if that's something he wants to consider, I'd like to keep him here so that Mr. Medina may have a chance to talk to him.
Okay.
Do you have my afternoon docket or rolled over to the end of this now?
Let's go on over, and I'll explain Mr.
Mr. Ask is going to be rolled for the Sunday morning.
What we're going to do is give you a chance to talk to your attorney there's been an offer made that you might want to consider that might, so, but just hang with us for a little bit. Your attorney's talking to somebody else. He'll be here in just a second. I mean, he's here, but, okay? That's what we're doing.
Okay, thank you.
Okay, we'll come back.
What's the recommendation?
Is Cameron Benoit here in the audience? Come on. Would the state announce this case? Come to the podium, please.
Is that Benoit or Benoit?
Benoit? Okay, sorry. 3 ways to pronounce that.
Is it Cameron, Your Honor?
Cameron.
That's with Mr. Morrow.
Pardon?
Mr. Morrow.
Okay, it's showing on mine that it has no attorney.
Benchmark shows Mr. Morrow as a lawyer.
What's the name?
Benoit.
Benoit, I filed that just probably late yesterday or this morning.
Okay, that's
I'm
fine.
Morrow from Mr. Benoit, Your Honor.
That's right.
I haven't had an opportunity to meet with Mr. Benoit. I'd asked the court to put us on the next miscellaneous statement of advice. If there's not already a denial on the record, I'd do that now.
Okay, very good. So we'll come back on, let's see, it'll be in the morning, I assume.
Yes, Your Honor.
We'll come back on April 18th. That'll be in the morning.
Your Honor, you said April 18th.
You've entered a denial.
You said April 18th.
Yes, not okay. July 18th.
Thank you, Your Honor.
Trying to be nice to you. Embarrassing.
I didn't catch it, Mr. Wasco did.
Thank you. Keep me straight here. That's why I need a whole group of lawyers to keep my dates straight.
I was writing down April.
And just for the record, Your Honor, the offer right now is revoke and terminate and send the financials to lien. So that Mr. Morrow has that offer.
Okay. The next case I have, it's a no attorney case, is Andrew J. Did you file on that one? Tomorrow? Did you file any other ones? Have you been appointed to any other cases that I'm unaware of that's supposed to be here?
My legal assistant had 2 days off this week, Your Honor, and I filed several yesterday. I have to refer to my docket.
So you need to check as we're going through. I'm going through the no attorney
And it
cases.
may register in my head as the court says.
That's right. So you're J. Andrew, the state announced.
Yes, Your Honor. This is Mr. J, or Andrew J.
Andrew J.
Case number 22 CF 2230. It's a VOP. I've had the pleasure of speaking with Mr. J before court, as did Mr. Rogers, who's been working with him. Mr. J has gotten a valid driver's license, and the offer that was extended to him was if he got a valid driver's license, we would revoke and terminate. So I asked to revoke and terminate at this time.
Very good. We will revoke and terminate the probation. You are completed, sir. We'll get you an order to that effect.
Yes, sir.
Thank you very much.
Thank you.
You are just on 6 months to pay any outstanding fees before they go to collections. I want to make sure.
Your Honor, there are outstanding fees, but my understanding was that the offer that was extended to him was that we were going to revoke and terminate. So I would ask that he have 60 days or 6 months to pay those fees before they go to collections.
Okay. Very good. Does that work?
Yes, sir.
I apologize, Your Honor. I'll be more detailed next time.
That's all right. Yeah, it's important to get into the details so that the defendants understand it and we get it in record time. Thank you.
Thank you, sir.
This is Dennis Keaton here. We come to the podium of the state analysis, another no attorney case.
Yes, Your Honor. This is Mr. Dennis Keaton, case number 22 CF 971. The offer in this case is to revoke and terminate and then send all outstanding money to collections.
Okay. Question?
Is there a way that we can avoid sending it to collections for 2 weeks because collections it adds percentages on this stuff. Because not this Friday, but the next Friday, I can pay everything off at that.
Your Honor, if that's the case, the state has no objection to continuing this case such that he could pay it, and then that would fix the problem.
We can't revoke and terminate and give him 30 days to pay it before it goes to collections. Can we do that?
I would be fine doing that, Your Honor.
Okay. So it keeps from having to come back. So the court will revoke and terminate. Is 30 days sufficient to pay?
Yes, sir. Yes, sir.
So I'll give you 30 days to pay. If not, it'll go to collections. Won't reinstate or anything. You're revoked. You're done with probation.
Yes,
But the fees will be payable or will go to collections after 30 days.
yes, sir. I just know that when they go to collections,
Good point. I know the fees are, can be a real hassle. That's an understatement.
Yes, sir.
Okay.
Thank you, Your Honor.
Thank you. Have a nice day.
You too.
Can you put Askew in the
Okay. That's all I've got as far as no attorneys. So, Mr. Harper.
Judge, all of mine are in custody. I'm not serving the public defender's
You wanna do-
office out of custody.
Sure.
Your Honor, do you
Yes.
have a Daniel Askew, A-S-Q-U-E?
That's the gentleman that was an inmate that,
And I'm about to go talk to him right now.
we had.
Yes, sir.
That's all right.
It was on the other side of the piece of paper.
That's all right.
Your Honor, I do have one I can take. It's actually on the afternoon docket. She came in early by mistake.
Okay.
It's Robin Grantham.
Was that one of the arraignments?
It is, Your Honor. She's scheduled for the 1:30 arraignment.
Okay, hold on. Where we adopted on. What, would you give me the name again?
Robin Grantham. And case numbers are 23 CF 928 and 23 CF 1073.
Gotcha.
At this time, we'll be entering a not guilty plea in both cases. They're currently scheduled, we'll take that back. We'll enter a not guilty plea in 23 CF 1073. We've already done that 23 CF 928. If we can have both cases scheduled for August the 14th at 9 a.m.
Very good. Continues to the next pretrial cycle on August 14th and 9th.
Thank you, Your Honor.
Thank you. Are there any other that the PD can, that,
I'll call Chris Wilson, Your
okay?
Honor. Ryan
Ron,
Harlan.
deal with the out of custody. What is that, what is the name?
Christopher Wilson, Your Honor.
Hold on.
And this is 21 CF 860. State's presented Mr. Wilson with a 6 months county jail offer, will look to terminate. He's been advised of that. He's also moving towards compliance with his conditions. So what we're going to ask the court to do is put this on our earliest July date, and I'll confer with the state and see if there's any renegotiation of that offer, or it may end up being paid from court.
Okay. So we'll come back on July 18th. Well, that'll be in the morning without screens.
Thank you, Your Honor.
And there's already been a
Yeah,
plea
it's
on it.
sticking, just haven't put a shoulder
Yes,
on it.
Thank you.
I have a few more, Your Honor, but these are cases that I anticipate will close today. I just need to get the terms from the state.
Okay.
And I don't know that I have any other custody folks here.
Mr. Medina, do you have any out of custody folks that are here that are waiting?
Not to my knowledge, Your Honor, I think mine are only inmates, but I could be wrong, but.
So we'll start bringing out the inmates, it'll be fine. We'll just go right from the top. Mr.
Right,
Harper.
we're ready for the argued inmates, and we'll start with back up.
Mr. Harper.
How much after we discuss.
Starting with Farrakis. Rebecca Farrakis.
Farrakis, took the Western, please.
Judge, this is Rebecca Farrakis, 22 CF 2327 and 23 CF 1067. Judge, this is set before the court this morning for a bond hearing. I will would be, for purposes today, adopting the previously filed motion by previous council with respect to a bond. However, in summation, the state is amenable to stipulating to a signature bond as to all of her counts and charges. And with respect to the violation of probation, which is 22 CF 2327, the state is amenable to stipulating to a $2,500 signature bond in that case. That should enable her to do that.
Okay, so just for the record, give me the two amounts.
Yes, sir.
In which cases?
With respect to 22 CF 2327, we're changing that from no bond to 2,500 signature.
Okay.
With respect to 231067, all of the cash and professional bonds will be converted to signature.
Okay. So, what's the total on that? You said it was 25,000 signature.
2,500 on the previous case, Judge. As to the present case, 23 CF 1067, I believe each of the possession of drugs without description would be 3,500 signature on each count. With respect to the fraud charge, it'd be $1,000 signature. And with respect to the possession of a new legend drug, it would be a signature bond of $1,000. I think the other counts are already R4.
Is the state in agreement?
That's correct, Your Honor.
Okay. Court will grant the change in bond as put on the record.
Thank you, Judge.
Just give me an order.
Yes, sir, I can do that.
Okay, next is Stoudemire, Jeffrey Stoudemire.
Yes, sir. This was set for status. This is 2 CF 1617. Judge, this is a post-conviction motion. We're going to ask that this be set for an afternoon hearing in July.
I will not be available in July, Mr. Harper, I'm sorry.
Right. I think, yeah, you mentioned. But for that, the next available hearing date, Judge.
August 17th. How long do you anticipate that hearing?
Judge, I anticipate calling 2 witnesses. So I would say about 2 hours.
The state would agree. The state actually believes this can be refuted on the record, so I'll get all that to the courts delineated as to what I'll be referring to beforehand, so that hopefully will expedite the hearing as well. And I'll be sure that Mr. Harper has copies of that, because I don't know if you got all the old VHS and everything.
Okay, so we'll come back for an evidentiary hearing on August 17th at 2:30.
Thank you, Judge.
The next one I have, Judge, for some reason he was not transported, is Darius Wilson. He's before the court on 20 CF 998. 20
Now,
CF.
my doctor didn't show that he's a inmate, but he obviously.
He is, Judge. 20 CF 999.
Somebody behind you.
Oh.
What date did you give on salary?
17, August 17th.
What's the name?
Judge,
Darius Wilson.
he's before the court on, I didn't see that there, sorry. 20 CF
2020 CF 998.
and 20 CF 999.
Correct.
20 CF 2791. 21 CF 1350. 21 CF 1490. 21 CF 2700. And 22 CF 189. Judge, I think we do have an administrative matter that we need to address with respect to 21 CF 1490. When he was sentenced on April 20th, that case number was erroneously left off due to a scrivener's error. It should have been incorporated into the plea agreement. I have a motion and stipulated order to incorporate that into, just add that case number to the plea on the approach, Judge.
And the state has no objection, Your Honor, that was the intent of the parties.
Based on the stipulation for
Judge, with respect to the violations today, we're going to enter a denial, and if we can set this for a hearing dates in, she's not available in July, if we can set it for August.
Is it going to be an evidentiary, sir? If it's not, we can go ahead and on the July docket. Someone else can do that, it's not a problem.
I think it might be prudent just August.
Okay. No subpoenas then?
Or we can do it in July, and if it's not able to be resolved without it, eventually we can come back in August.
Yeah, that's fine. We'll definitely speak before then, so I can leave it. It's not a problem.
So why don't we come back on July 18th morning?
And I'm sorry, did you deny that on the record, sir?
Yes, ma'am.
Okay, thank you.
That's correct, these are all done.
Your Honor, if I can also address one case that's on the afternoon docket. I believe it's on the 2:30 dockets, number 4, Willie King.
Correct. I understand.
Judge, there's, essentially I have a personal matter that I can't reschedule, unfortunately.
I already understood that it was going to be continued.
Yes, sir.
So,
if I can get the next available afternoon hearing dates, the state and I have actually been in contact. If we can actually do it in July, if we come to an agreement beforehand,
sure.
We might be able to just resolve it that way.
So it'll need to be in the afternoon. What was July? What do we got on July 11th?
It's filling that fast. Yesterday.
So it doesn't really matter if you do it in the morning.
We can do it in the morning, Judge.
Okay.
It would not be a hearing at that time if we've got it resolved, and if we haven't, then Mr. Harper, I believe we've agreed, will ask to move it to the next available.
Okay, very good. So we'll continue it until July 11th.
Yes, sir.
In the morning at 9 a.m.
Thank you, Judge. That's all I have today.
The scout and I are set for 2:30, because you're not going to be here for the month of July for the afternoon.
Correct.
Thank you.
Gates?
I have one in custody.
You want to do it?
I can handle it.
Ready for here.
Is it Gomez? You pronounce it?
Gomes, Your Honor.
Oh, sorry, Gomes. Mr. Gomes, select that, please.
Yes, Mr. Gomes before the court in 21 CF 2890 and 23 CF 216. The state and I have talked about the status as far as his cases are concerned. If we can move him to the July 11th date, my anticipation is that we'll probably enter a plea at that point and either set sentencing or resolve the case.
So in the morning?
Yes,
Without
sir.
subpoenas? July 11th at 9 a.m. without subpoenas.
Yes, sir.
So, thank you, Mr. Gates. Ms. Morrow, you ready? You want
I
to begin?
can call pretty much any of my inmates, Your Honor. There's one that I'd like to get a plea agreement back to before I do, but the rest of them I can take in real time.
I don't know which one are yours as opposed to the others.
I can just go down my list if you'd like, sir.
We're gonna have to get them lined up.
Okay.
Yes. You have your list?
I do, Your Honor.
If you give me a list of names now, it's gonna be violation of probation.
I'm gonna hand my computer off to the deputy. Got the INC next to it. So we can call pretty much anyone to the office and see what they study.
It's difficult getting used to going paperless, but the more you get used to it, it's amazing. I mean, you're old school. Don't give up paper.
It's too late.
Our younger attorneys are more adept at computer, and it goes in spades for the judges.
Rank 32 through 41, please, in order.
I'm not sure, your list is the same as my list, so I'll let you call them out and I'll find them. How about that?
Sounds good, Your Honor.
What's the first one?
First one I gave the security is Broders alphabetically, but I asked that to be hold last because he's got to review paperwork. So next would be Mr. Clough.
Okay, I've got them alphabetical, so if they're alphabetical, we're in the same.
It should be, Your Honor. This is Mr. Giles, Your Honor. Ryan Morrow for Mr. Giles. If it hasn't already been done, Cloth, I assume that they're going to bring it to me in Mount Delaware. I'm sorry. This is
Richard Giles.
Yes, Your Honor. State's made a guideline offer in this case. Defense has some discovery that they need to close to the state. I'm asking the court to continue this to the earliest July date that we have, and then I'll provide that information to the state. If that doesn't result in a negotiated plea, this will likely be a plea report.
31, possibly in the
So July 11th in the morning without speeds?
Yes, sir. Yes, Your Honor.
9 a.m.
Mr. Gray?
This is Mr. Gray, Your Honor, Antonio Gray. You have a moment, Mr. Gray, Your Honor.
You won't, honey, but Gates is in there right now, so they'll be able to look at it.
has been presented with the state's offer. It is a DOC offer. I'm asking to keep past the 7/11 date if that's not already too backed up. And at that time, we're anticipating either a plea to the court or a negotiated plea.
July 11th at 9 a.m. Yes, he is, I assume he's entering a denial.
He is, Your Honor.
I need, hold on a second, I need to talk to the state and Mr. Merrill.
Call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit
Ryan Marcus, Your Honor. Similar situation here. The state has made a guideline offer in this case, so I anticipate there will be an admission, but I don't know whether that will be a true negotiated offer or to the bench. So we're asking for that 7/11 date.
Okay. So we will, has the VOP been pled already?
This is my first time on this recall in the courtroom, so I will enter a denial if it hasn't been.
We'll deny it. We'll come back on July 11th. That's our first miscellaneous without subpoenas in the morning at 9 a.m.
Thank you.
Thank you. One of the challenges we have when we have these weeks where we have 2 pre-trials, there's a lot of cases, and the court understands that. We're trying to, we just don't have any other days to get them on. It makes it hard for everybody to get these things done.
Yes, sir.
May I have a moment for everyone, Your Honor? Your Honor, Ms. Green might have this matter set for a contested hearing. I'm sorry, let me repeat that. I have my finger on the button. Ms. Green would like to set this matter for a contested hearing.
Okay. How long do you anticipate the hearing to be for?
There may be some witnesses called from the defense in this case, Your Honor. From a defense perspective, with the state's case and what the defense could potentially be calling, I'd say maybe an hour on the high end.
I would tentatively agree with that. I don't think it's going to take any more than an hour and a half. So there are several witnesses I think the state's going to have to put on. It's not just going to be one person.
Is there an, you said there's a guideline offer?
The offer is not guidelines, Your Honor.
What is the offer?
The offer is 18 months DOC.
What's the guideline?
She scores 40.
Minimum guideline.
She scores 43.8, so she doesn't technically score. So based on the totality of circumstances, the state believes that that's the correct offer to make in this instance.
What are we looking like?
July 18 is at 5 already, because you scheduled one today. That moves you into August.
Let me what do we have on July 22nd?
I don't even see that as an available date for you. So let me just go back to
I'm
benchmark.
sorry, did I say July? June.
Okay,
No, not
June 22nd, 1:30, okay.
Can we do it faster if we, this?
You've got 9 scheduled already.
Okay, forget that.
Your jury review in the morning for June 22nd only has 2 cases. Today's the 15th, that's just 7 days away. I doubt, I'm not trying to.
Well, the jury reviews, we got a whole bucket.
Yes, sir.
I'm assuming we're gonna pick up
Add
some jury
jury.
reviews.
You have 2 in the morning so far and 9 that need to come in at 1:30. 9 defendants.
On June 22nd, we have 9 cases in the afternoon. And who stacks those up? We just have one other one on June 22nd on the jury review and one.
Yes, sir, and you offered that.
Right, that was just yesterday. Yeah, yeah, let's try and do it in the morning.
On 22nd, Your Honor?
Yes.
The only concern from the defense perspective is my clients asked me to locate a couple of witnesses. I have not yet been able to do that. I just want to put that in the court's ear for now. But I also don't want to continue it into the ether for also the benefit of the screen.
Okay.
So we'll leave it there for now, Your Honor.
On the 22nd of this month?
22nd.
And that's in the AM, you said, Your Honor?
Yeah, we schedule everything 9. We've got to have jury reviews first, so it'll be, say 10 o'clock.
Understood.
It won't be before 10. Okay, very good.
Harper?
What is the next?
This is Loretta Harper, Your Honor.
Got it.
Ryan Morrow from Ms. Harper. If it hasn't already been done, the defense of preliminary denial from Ms. Harper, we're asking for the court to allow us to continue this matter. We're waiting for an evaluation from an inpatient treatment facility called Path of Grace, and that's going to be the resolution we're seeking for this case, Your Honor.
Do you have any sense for timing?
I know, I can tell the court that the eval's already gone out. What I can't say is what the turnaround typically is. I think maybe I've gone through this program maybe one other time, so I can't really say, but I have no reason to think it would take longer than our day on the 11th. In my experience with most of these things.
Morning on July 11th.
Yes, sir.
Okay, we'll come back on July 11th. Does that work all right?
That
It's
is fine.
the Path of Grace is a very good program, Mr. Morrow. You can be aware of it.
Thank you, Your Honor.
And utilize the dependency process.
Okay, understood. We appreciate that.
Thank you.
All inpatient programs are not alike.
Understood, Your Honor.
That's a good one.
This particular one I'm not experienced with, so I appreciate the court's input.
It's just been my experience with it.
I'm looking out there, it had to take me a minute, so as far as we can get right now. But, we're ready for trying that passing every year back.
And Your Honor, when the time comes, if we could just push 2 towards the bottom of the docket, because Mr. Morrow and I expect him to plead, and we have to hammer out the details.
That's fine. Any of these need to work on a little bit. We'll pass it. What are the ones you need to pass over?
Number 31 of the docket, Jude Truss, Derek Jude Truss, and then Ms. Snowden. Holly Snowden.
Very good. We'll push through and get the remainder of yours done, and then we'll probably take a break and you guys can meet.
Sure. Thank you.
Guess they had to get lunches.
Sure. We're gonna do the female versus like her, if you want to get me set up.
No, because you can't have
Ryan Morrow from Ms. Kirkland, this is 22 CF 2682. If there has not been a denial entered from Ms. Kirkland, we would do that at this time. The defense is asking this case be passed to 7-11. The state's made an offer of 12. Hold on.
I'm sorry. What case are we on?
This is Ursula Kirkland, Your Honor.
Okay, I'm sorry. Go ahead.
Ms. Kirkland, having heard the offer from the state, she'd like to accept that as opposed to seeking reinstatement. She'd like to accept that as opposed to seeking reinstatement, just so she doesn't have any additional supervision. But I did not prepare paperwork for that pursuant to our conversation previously. If the court would give me a pass, I will prepare that paperwork and we'll try to resolve this matter today.
Perfect. Okay.
Thank you. Go back.
Yeah.
I'll come back and talk to you about that.
He's gonna write a plea up for her.
Yeah.
Okay.
Your Honor, this is Mr. Jackson. Can I have a moment, Mr. Jackson?
Sure.
We'd like to set this matter for a contested hearing, Your Honor.
What's the offer?
12.1 DOC, Your Honor.
What's the defendant's exposure? State?
One moment, Your Honor, I'm looking up.
I believe it would be 10 years, Your Honor, based on what I'm seeing on the docket, one count of felony battery and one count of obstruction.
Have you had a chance to fully review all this with your client, going over facts and stuff? If you're just getting the offer now,
I am just getting the offer now, Your Honor, but apart and aside from the offer, I was already kind of anticipating setting this matter for a contested hearing, so I don't think that's necessarily the reason. We already had discussed the potential for a contested hearing based on the allegations of the violation.
okay. Very good. How long do you anticipate a contested hearing?
This one may be longer. The state was listed at least 2 lay witnesses, and I anticipate the defense will call at least 1 lay witness and probably the defendant himself for testimony.
August 22nd. What do we got?
We don't have any cases scheduled at 1:30 for August 22nd.
We'll schedule an evidentiary hearing August 22nd at 2:30.
And Your Honor, since it's been set so far out, the allegation is a simple allegation of contact with the alleged victim on the underlying case of probation. I was going to ask if the court would be inclined to entertain a motion to instate a bond for Mr. Jackson in this case.
Can I ask for it?
Your Honor, of course, Mr. Morrow can file a motion to ask for it. However, I would say that this isn't a case of simple contact once. This is a prolonged contact over the course of several months is what's alleged in this affidavit. So I don't think it's appropriate, Your Honor. We also need to give the victim opportunity and notice today.
And I have discovery that would be relevant in the hearing and in the violation. I think the state needs eyes on that as well.
Okay.
And I'm sorry, what date did the court give for the hearing? For the
August 22nd at 2:30.
Thank you, Your Honor.
And this is why, Ms. Marsh, just so you understand, court takes a little extra time when we're entering pleas, when there's no contact on these plea agreements, to explain to people that no contact means no contact.
Understood completely, Your Honor. This is Mr. Larry King. Your Honor, may I have a moment, Mr. King? Mr. King is asking for a contested hearing in this matter. Your Honor, I'll enter a denial if that has not already been done.
Court will enter a denial. How long are you going to require on an evidentiary hearing?
This will be brief, Your Honor, whatever time the state needs, and there's perhaps some brief testimony from Mr. King.
State?
I would agree with that, Your Honor. I think it's just going to be brief, no longer than probably 40 minutes.
This is on misdemeanor matters, they were put down, so for the court's emergency.
Right.
So 11th, we're all filled up on.
Oh, yes, sir.
And July 18th. Yeah, that's back after.
I've got 4 defendants on July 18th at 2:30, but I'm concerned if some cases were set this morning. Just check really quickly. Like, so far, all you've said is 9 a.m., so you do have one slot available. I kind of know what to ask questions because these are longer hearings.
Sure. Let's try and do it on July 18th.
That'd be AM or PM.
Yeah.
Your Honor, this is Tyree McClendon. He has 6 matters before the court. The last time we were here.
Why don't you announce the case numbers?
Yes, Your Honor. That'd be 18 CF 2721, 18 CF 3060, 18 CF 3061, 18 CF 3062, 18 CF 3063, and 18 CF 3064. The last time we were here, we sought a continuance to allow time for Mr. McClendon to be evaluated for the Veterans Treatment Court. It's pretty unclear to me what happened with the paperwork. Someone is saying that he refused, and he's saying that that's not the case, so I don't have a good explanation as to what happened. Since then, I've reached out to Mr. Rivera to get the process started again. It's my understanding that everything is now done, but we still haven't heard back from the Veterans Treatment Court. So I'd ask that this matter be passed to assume a convenient date in the future, either 22nd or the 11th, and we'll see where we're at with the Veterans Treatment Court. If not, it may be.
Only come back on July 11th in the morning.
Thank you, Your Honor.
No, let's do the 18th.
Very well, Your Honor. That's fine.
July 18th, 9 a.m. without subpoenas.
All right, we can turn it back. We need to write this way, sir.
Got a lot of cases.
Smith and McClendon, right this way, sir.
Do you announce, counsel?
This is Reagan Turd, Your Honor.
I'm sorry, I didn't hear that.
Reagan. Thank you. 21 CF 2306, 21 CF 2321.
Yes, Your Honor. May I have a moment? Your Honor, Mr. Reagan's been presented with the state's offer. It is 11 months in the county jail. We've just been presented with that offer. He has some other things he'd want me to put in the state's ear, so I'd ask that the court put this on either the 11th or the 18th. We do anticipate a resolution in this matter. It's just a question of whether we plead with the court or plead with the state's offer.
July 18th in the morning without subpoenas.
I'm sorry, what date is that?
18 July.
Thank you, Your Honor.
I have one that's a non-inmate, Jeffrey Soul.
To my knowledge, he was out of custody.
That's correct. To your.
We'll have Mr. Jeffrey Soul in the courtroom. His name is on.
We'll deal with that in a second.
Robert Lewis.
Your Honor, there was some confusion about the terms of the state's offer and whether or not it was something he could accept. Mr. Willis has let me know that he would like to accept the state's offer, but I don't have the paperwork prepared. If we could pass him to the end, and I'll draft that up and close this case today.
Tell me your name. Robert. Okay.
Now, Ryan Marlowe from Mr. Willis, 21 CF 3281, Your Honor.
Frank, Mr. Willis is going to plead, but they need residence.
You want to
I just was.
Yeah, I'm going to
I think we're about to take a recess.
Okay. State, Jeffrey Soul is not in custody. Tomorrow.
I don't have any information.
19 CF 360, 19 CF 688. Got any information?
I don't, Your Honor.
The state would request a capias.
Tomorrow?
Nothing from the defense, Your Honor. This was passed to await resolution of a matter in Alabama. And I haven't heard from
Court order, no bond capias. Okay. Other than the ones you got to back up, double back on, do you have any others?
Yes, Mr. Broadhurst has had time to review his paperwork, then we can go ahead and resolve his matter.
Brock?
Hey, it's number 30, Mr. Brockers. We're ready to do number 30, Mr. Brockers. It's just a second. Let's pass this to once. Number 30, Mr. Broadhurst.
Ryan Morrow from Mr. David Broadhurst, Your Honor. This is 22 CF 319.
So we'll do this one, and then you've got about 5 others, and you've got a double, you know, more than 5, then 1 and 3. I'm listing here what I've got.
I have Snowden.
Jetris, Kirkland,
Oh, I forgot about Kirkland, Your Honor. Yes.
Snowden, and Willis. That's 5, I think.
Your Honor, this is Mr. David Broadhurst, 22 CF 317. This is going to be a negotiated plea. As to the VOP, what we're going to be asking the court to do is to revoke and terminate his supervision, 100 days in Okaloosa County Jail with credit for all time served, $100 VOP fee, $150 cost of defense, all financials to reduce the lien 1 year after his release. It will be adjudicated. The pre-sentence report is not required. I'll pause and give Mr. Broadhurst an opportunity to sign.
Is that the state's agreement?
That is the state's agreement, Your Honor, and I believe the defense should already have a score sheet.
No objection.
Okay.
May I approach?
Rogers, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you heard your attorney state the terms of your plea agreement. Those same terms are contained in the written plea agreement that I see you've signed. Have you read this plea agreement closely?
Yes, sir.
And have you gone over it in detail with your attorney to make sure you had all your legal questions answered?
Yes, sir.
You understand by entering into this plea agreement here today that you're doing so freely and voluntarily, and that this will be a final resolution in your case. You're waiving the right to go to a trial.
Yes, sir.
You understand that? Believe that's in your best interest?
Yes.
Nobody threatened or coerced you to get you to enter into this plea?
No, sir.
Based upon that, the court will accept the plea agreement, and there will be, we'll vote and terminate. I assume that's what R/T
It is,
means,
Your Honor.
Mr. Morrow?
It is.
I don't know that anybody else could read it, but I just.
I apologize for doing that one by hand.
For 180 days in the Okaloosa County Jail, you will get credit for all time served. $100 DOP, and then the other $150 cost of defense. All the financials will go to Lee. Can't read that.
That's 1 year after release, Your Honor.
1 year after release. Okay. Very good. Thank you very much. Good luck.
Thank you, Mr. I'll allow someone else to press some cases.
Okay.
Or we take a recess.
Yeah, let's take a short recess, and then we'll come back. Mr. Medina will start your cases here when we come back from recess.
Yes, Your Honor, ready to go.
Okay, give me about 10 minutes to stretch.
Thank you, Your Honor.
I'll be, we'll be back.
All rise, please. Court's in a 10-minute recess.
Whatever you say, sir. Go ahead and make your
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Thomas Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning, so come on down and take a look.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law.
I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boys Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Thomas Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning, so come on down and take a look.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Pretch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Background Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boys Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Island's burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Tom's Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning. So come on down and take a look.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays, 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestvew's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Office. We're actually going to be taking a plea in a CT case as well. 23 CT 1195. Yes, Your Honor.
Was this your case or Mr. Medina's case?
It would normally be mine, but I think my colleague was doing.
No, I was trying to find it.
He was unrepresented.
What?
He was unrepresented.
Yeah.
That's what it was.
And then you guys appointed.
So I'm just trying to, half my battle here, trying to find this on the battle. Very good. Sorry.
That's all right, Your Honor. We are going to be admitting the violation before the court in 19 CF 3282. There is a pending misdemeanor case, 23 CT 1195. The state has agreed to take a plea in that case as well. The result will be that Mr. Askew will be eligible for release today. That's why we're trying to go ahead and work this out as far as his case is concerned. He'll be admitting the violation in 19 CF 32A2 with no contest plea as charged. Another case, if I may approach, Your Honor. And the state will provide a score sheet later, Your Honor. Okay.
Yes, Your Honor, we're printing the score sheet out now. We'll provide it with you.
There's no downward departure.
No, Your Honor, he scores only 43.2 points, so he misses scoring 12 on POC.
You're doing that.
Yes, Your Honor. Mr. Askew is going to enter a plea of no contest as charged at 23 CT 1195 and admit the violations in 19 CF 32A2, be adjudicated guilty in all counts and cases. In 19 CF 32A2, we're going to revoke and terminate probation, sentence to a new term of 12 months community control. I'm realizing I gave my copy to the court. It's not signed by anybody. I'm sorry. Do that real quick. I got ahead of myself, and I do that periodically. No, it's official.
Thank you.
In 19 CF 32A2, Your Honor, will be revoking and terminating his outstanding supervision, sentenced to a new term of 12 months of community control, concurrent between all counts and cases, waive the cost of supervision fee, required to complete any original requirements, $100 cost of prosecution, and $150 defender fee. In 23 CT 1195, 11 months and 29 days of probation concurrent. We're going to waive the cost of supervision. I have the court cost is 50173 because that's what I've seen the state send over. I don't know how we got there, but it's whatever the standard court cost is on the DUI offense.
It would be a $500 fine, $438 in court costs, a $25 surcharge, and then a vehicle impound of $13.73.
So that I see that's where we get the 73 cents from. The standard court costs associated with DUI is how I'll say it, Your Honor. $100 cost of prosecutor, public defender fee, substance abuse evaluation due within 30 days of release, and you recommend the treatment within 60 days, random urinalysis, 50 hours of community service work, $500 fine, DUI school, victim impact panel, 10-day vehicle impound, and a 6-month driver's license verification. And as we were just appointed to Mr. Askew's case, I haven't had an opportunity to review the discovery in the DUI or in the DOP case, so we didn't plead without having that.
State, you agree?
That is the state's agreement, Your Honor.
Mr. Askew, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard your attorney state the terms of the plea agreement, and I see those same terms are written in the written plea agreement that you've signed.
Yes, sir.
Have you read this agreement?
Yes.
And have you gone over the detail with your attorney, make sure you understand all the legal ins and outs of this?
Yes, sir.
The main thing is you agree this will be a final resolution of these cases, both your violation of probation as well as your misdemeanor charge. But you are waiving some valuable legal rights, right? You go to a trial, force the state to prove their case, all those things. Say, hey, let's get this done today. And so you're waiving those rights. Do you understand that?
Yes, sir.
And you're doing this freely and voluntarily?
Yes, sir.
You know, you're twisting your arm.
No, sir.
No? Okay.
But it's probation, it's 12 months, right?
Yeah. So
12 months total.
Okay.
So what you've got, let's go over that just to make sure you understand, because you've got 2 probationary periods for each of your case, one for each of your case on your 3282, where you had a violation of probation, you got a new term of 12 months community control.
Yes, sir.
That's the main one you're really dealing with.
Yes, sir.
Community control is a little higher supervision, like house arrest, really. It's a better term.
Yes, sir.
Okay. Now, on the other one, your misdemeanor, it's 11 months, 29 days probation, but it's concurrent with the other, so they're running at the same time.
Oh, okay.
So you got a total of 1 year community control. That's really the focus.
Do I have to go to like 2 separate places?
No.
They're gonna
Same person will supervise, they'll track parallel. You go to the same person, you got one person or one organization you're dealing with.
Yes, sir.
You don't have to worry about it.
And I discussed that with probation. They're gonna monitor that for the court as well.
Okay. That's a good question. You want to make sure that, you know, get this 12 months, you know, want you to be successful with this. So there's some, of course, there are always some additional fees and costs that are contained in here. And the substance abuse evaluation and recommended treatment, you gotta get on that right away, okay?
Yes, sir.
50 hours of community control and the other DUI, et cetera, that are part of this agreement.
Yes, sir.
Okay, any questions?
Yes, sir.
Okay, good luck. Okay, as soon as you, sir, you do have 30 days to appeal this, even though you just entered into this agreement, it's a sentence, and make sure, as soon as you get out, go check in with probation.
Yes, sir.
Okay?
Just need to get your fingertips.
Okay.
And this is Coco Parsons. Leave Mr.
Oh, okay, yes, sure. Would you announce the
Yes, Your Honor.
what's the name?
Steve Medina with Coco P. Carthon, C-A-R-T-H-O-N.
Okay.
Your Honor, we are here for a bond hearing in both of her cases. 23 CF 905 is a new law case, and 21 CF 2665 is a misdemeanor case. Beyond what's in the motion, the points I wish to try to emphasize is, as far as the overall situation, my understanding is this is the first violation of probation. Obviously, we're not resolving that at this time, so I'm not making the admission, but it is the first alleged violation. There's no prior FTAs, and also is that she represents that she does have housing to live with her mother, and I'm asking for a signature bond for the court to please consider a signature bond in both cases, and that I don't have anything further to argue at this time. Did you want to say anything without talking about the facts of your case? No, sir.
Steve?
Your Honor, the state would be opposed to a signature bond. She has a significant criminal history, and she picked up this new charge not long after pleading to her old job, Your Honor. See, she's got 21 CF 2665, which is possession of cocaine. That's for violation of probation. And then she picked up a new battery, Your Honor. So she's not been successful so far. We believe that a $3,500 cash or professional bond is what is required.
What's the current bond set at? 35 for that? Is that the current bond?
Yes, Your Honor, in the new law, no bond right now on the BOP. If I could, whatever Ms. Sandler's done, I wanted to mention a couple other things.
Sure. I just wanted to make sure that there's no bond on the BOP.
Yes, that's
$3,500 cash professional on the other?
Yes, Your Honor.
Okay.
And Your Honor, just to clarify, I do have 2 prior failure to appears for Ms. Kaufman.
Your Honor, I don't know the nature of those failure to appear issues. Sometimes there can be complexity with no real willfulness, but in any event, 2 things. Is on the BOP, I just wanted to mention that she did not enter the probation resolving 21 CF 2665 until our records show March 21st, 2022 was when that was disposed of with the 2 years probation. So she did go a considerable period of time without a violation. And that the point I didn't really clarify, but with respect to the fact that she can live with her mom, the point being is that sometimes when there are battery type situations, there's difficulty of avoiding the alleged victim, but here there won't be any problem doing that. And I would
alleged victim, her mother?
No, Your Honor, it was a totally unrelated individual. You don't have familial relationship with him. And he will not be at that location with your mother. And if, Your Honor, if there were a concern for showing up for court, obviously GPS is a potential additional condition of pretrial release. She thinks maybe she was in jail on those prior FTAs, but I don't have any further information.
So what is the state requesting?
Your Honor, the state's requesting that the court leave her bond as it is set. We're not asking for any increases. We're asking the court not decrease it. The nature of her new offense is an unprovoked attack on somebody else while she was on probation for cocaine. This is not a family dispute. This is an unprovoked attack. We think that definitely qualifies for a cash or professional bond, Your Honor, not a signature bond. And she has no right to bond on a violation of probation.
So the current bond is $3,500 cash or professional on the felony battery, and then a no bond on the BOP?
That's correct.
What was the prior on
the underlying was, my understanding is possession of controlled substance.
No, I understand. What was the bond on that?
Oh, well, because it's a BOP case, there was no prior.
That's a BOP, that's a new one. But what was the old one? You know, did she bond out on that?
I don't think she ever bonded out, Your Honor, because she picked up the new law, and I think she's only had one first appearance.
Okay. The court will, court's going to continue the $3,500 cash or professional on the new law charge, and the court's going to issue a $1,500 cash or professional on the underlying on the BOP case.
Thank you, Your Honor. Can we present an order? But I won't have it with me today. But Madam Clerk, if you could note that for the jail, then if you can post that, it sounds like a total of $5,000 between the two cases, cash and professional. So that'd be $500 to Bronzman if you can get one.
So the BOP now has a $3,500 signature.
No, the BOP now has a $1,500 cash or professional.
For all three counts?
Correct. Well, yeah, so.
All right, I'll put that in.
I show her on your 130 docket. Did you want to handle that as well?
Yes, Your Honor, she could go ahead and deny the BOP if she was, well, she was on the plea day docket.
For the new charge?
Yes, so we can go ahead and plead not guilty on that and resolve the arraignment.
That way we can send her back.
Yes, sir.
Same with Christina Chenault. She'll be next.
Okay. Or to enter a not guilty on the new charge, and we'll come back on 8/16 at 9 a.m.
So your next court date is going to be August 16 at 9 a.m. That's your next court date. Okay? Hopefully you can make it fine. Thanks, Bennett. make center appointment if you get out.
Okay, thank you.
Otherwise, I'll be deceived.
Okay.
Thank you, Your Honor.
Thank you.
Ms. Chenault? Thank you, Your Honor. Your Honor, Christina L. Chenault is approaching, and we have a worked out plea and sentence agreement that Ms. Chenault is signing. And we do need a score sheet on this one.
Your Honor, the state's presenting the defense with a score
Thank you,
sheet.
ma'am.
She does not score. This would not be a normal departure.
Yes, ma'am. Thank you. Just 1 second.
Ms. Carthen did put in a DOP denial, correct?
Yes, ma'am.
Yes, thank you.
If I may approach with the agreement and score sheet, Your Honor, it's, if I get it in the right order. 1, 2, 3, 4. You ready for Harper? Thank you, Your Honor. And if I may just, before I announce, give probation a copy. Your Honor, under this agreement, Ms. Christina Lynn Chenault would be adjudicated guilty as charged. I do note that based on the information that has been provided by the state in the score sheet, this is her going to be involving her first felony on count 1, so she will become a convicted felon. I've advised her of that. Under the agreement, there will be 24 months probation on count 1 with 11 months, 29 days concurrent probation on counts 2 through 5, which are misdemeanor counts. $150 public defender fee, substance abuse evaluation within 30 days with any recommended treatment to commence within 60 days. Random urinalysis, 50 hours community service, may be waived by state probation if she proves she's physically unable. I don't want to get into the details, but she has major health issues that are very serious, so she may be able to provide that proof to state probation that she's not able. 1 year driver's license suspension, maintain gainful employment or complete 2 job applications a week, and waive cost of supervision. And again, that's taking into account what I could explain in confidence if I needed to about her medical situation. No weapons or firearms. There's a $1,000 fine because there was a DUI charge. That's count 5, DUI school, victim impact panel, 10-day vehicle impound. I do note for the record that she advises me she has a Mississippi hold, so I don't know when she'll be released, but whenever she is released, and she will have to report immediately to Fort Walton Beach probation.
State?
That is the state's agreement, Your Honor.
You pass your name, Chenault?
Yes, sir.
Ms. Chenault, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the written plea and sentencing agreement that you're checking, you've signed.
Correct.
So my first question is, have you gone over this plea, have you read this plea agreement closely?
Yes, sir.
And have you gone over it in detail with your attorney to
Yes,
make
sir.
sure you had all your legal questions answered?
Yes, sir.
You understand, by entering this plea agreement here today, you're waiving the right to go to a trial and to contest this will be a final adjudication of your case. You understand that? I believe that's in your best interest to do that.
Yes, sir.
And you're entering this freely and voluntarily.
Yes, sir.
Very good. Based upon that, the court will accept your plea. There'll be an adjudication of guilt as charged. As to count 1, court will sentence the defendant to 24 months probation with, and on counts 2 through 5, court sentencing to 11 months, 29 days probation. Those will all run concurrent. Okay, so all run at the same time. You got a number of, you got fees and costs that are contained in the agreement, some other things, including but not limited to the substance abuse evaluation within 30 days, commence treatment within 60, random UAs. Basically, the thing to understand about this isn't the end, this is the beginning. You're going to have to pay attention to this, show up where you're supposed to, maintain good contact so you can be successful. Because we don't want to have to come back in and spend any more time in an orange outfit, okay? So, there's a $1,000 fine, DUI, school, and the other things that are contained in the plea agreement. Any questions?
No, sir.
Good luck.
Thank you.
And the defense is okay with the
Yes, Your Honor, we have no objection to the score sheet. And if she wants to appeal.
And then you do have, even though you're just entering into this agreement, I can tell you, you have 30 days to appeal.
And Michael Bennett to the left.
Oh, does this cover her arraignment in the second?
Yes, this resolves the need for her to no need, because she's gone ahead and changed her plea right now.
Okay.
Your Honor, on Michael A. Bennett, 20 CF 1937, I think we're going to have an 18-month prison deal. Can we do it now, or do you want to do it later today?
Excuse me, we can do it now. I just need to be able to get the court score sheet and announce that it will be a negotiated downward departure based on negotiated plea.
And Your Honor, we had a different amount of incarceration on the agreement that I sent back, but I discussed the 18 months with him, so if I may have just a moment to change the incarcerated sentence.
Okay.
I'm changing it to 18 months DOC. And that's with credit for all time served. And I'll go over the particulars. You understand?
Yes, sir.
And you read it? You ready to sign?
Yes, sir.
It's going to be revoked and terminated 18 months DOC. May I approach, Your Honor?
May.
Oh, I do need the state signature as well, Your Honor. And I appreciate Ms. Sandler filling in and working this case out. Thank you, ma'am. Thanks, sir. May I approach you? So, Your Honor, as is indicated on the VOP agreement, he will be adjudicated guilty, but he was previously adjudicated guilty on the underlying felony. It will be revoke and terminate the existing supervision. It'll be 18 months DOC with credit for all time served. $100 VOP fee, $150 public defender fees, outstanding monetary obligations to collection 6 months after release.
And you're okay with the score sheet?
Yes, Your Honor, no questions on the score sheet.
Very good. Mr. Bennett, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you?
Yes, sir.
So, Mr. Bennett, you heard your attorney state the terms of the plea agreement. Pretty straightforward.
Yes, sir.
Just want to make sure you understand what you're doing and you're entering it freely and voluntarily. So you've signed, have you read the plea agreement?
Yes, sir.
You've gone over with your attorney, had all your questions answered.
Yes, sir.
I understand you're waiving the right to a trial, to contest all this. This will be a final adjudication of this violation of probation. Do you understand that?
Yes, sir.
You believe it's in your best interest to enter into this?
Absolutely.
Okay. You do understand that this is, will revoke and terminate all probation, all supervision. You know, you'll have 18 months DOC. You will get credit for all time served.
Thank you very much.
Okay? You got the fees and costs. Any monetary obligations go to collections 6 months after you're released from DOC.
Yes, sir.
Okay? Any questions?
No, sir.
Thank you very much.
Thank you all.
Thank you, sir.
Trey Vaughn Blunt. Trey Vaughn Blunt.
Your Honor, this is for the court, Trayvon Blunt. Mr. Blunt was here yesterday for his pretrial. He's back again today on a couple of bond motions that I think basically we're going to more or less, to some extent, resolve by stipulation, to some extent live to argue another day if the court is okay with that. So if I might, just on the record, it's Trayvon Blunt and 22 CF 2355. We have two motions. One was a Brady motion, and I discussed that in detail with Ms. Basso, and at this time I am representing that the motion to compel the production of Brady material is being withdrawn at this time because of the representations and information that has been provided by Ms. Basso. With respect to the motion to dismiss, an alternative motion for statement of particulars, to some extent, I think the state, I don't know if it's going to be put on the record today, but there are, I think, 2 counts that we're going to be able to work out. And with respect to other counts, we may end up having a motion to dismiss or reset, but we agreed it probably should be on the afternoon because there might be extensive factual and legal argument. It's really not appropriate for the morning. Moreover, Ms. Basso has agreed and volunteered to provide a written response which will maybe help narrow the issues. So if we could just basically for now take off the calendar the motion to dismiss with leave to revise that or revisit it if we can't work things out.
That's accurate, Your Honor, and what I'll do is I'll plan to address any counts that I'm conceding in my response, so the court will be aware of what we would not be arguing.
So at this point, we're not going to reschedule. We're going to wait to get your response, and then if you need to reschedule it, you can do that.
Moreover, yes, Your Honor, absolutely. And moreover, we've also had a productive discussion with the state about maybe resolving a case on the merits. So he's going to be, with the court's permission, returning on docket day this Monday, June 19th at 9 a.m. for a possible resolution. It's with a plea or continue.
Very good. So the court will continue the case, or not continue, but continue the case until October, until
June 19th.
June 19th. June 19th at 9 a.m.
That's it. Thank you, Your Honor.
Thank you very much.
Michael Brown.
May I have just a moment to advise Mr. Brown of some information, Your Honor? Sure. Your Honor, at this time, I've advised Mr. Michael A. Brown, who's before the court in 23 CF 438, that we do need to go forward with that bond hearing because the other case that he has, 23 CF 1228, it involves alleged victims, so the state would have to have some probably extensive victim communication before we could get a global resolution, if we can get one, although I'm still hopeful that.
You're talking about global resolution as to the bond issue, or?
No, Your Honor, I'm just my background, a little too much information probably, but I still hope we can work out some sort of a deal to get him some treatment that he knows he needs. But at this time, we'll just proceed on the motion of bond for bond reduction.
Okay.
It's actually, that's a poorly worded motion. I apologize. Basically, he has no bond right now. He had bond in 23 CF 438, but it was revoked when he picked up. I'm sorry, Your Honor.
It's all right.
Your Honor, he's clarified for me, and I do appreciate that. I apologize that it looks like I misstated, but he says there was a misdemeanor charge that maybe intervened before he caught the second felony case that involves Santa Rosa County, or?
Misdemeanor resist arrest, and I resolved that.
Okay, but in the event, he has bond in 23 CF 1228. He does not have bond in 23 CF 438.
What are the underlying charges on 1228?
On 1228, the underlying charges, even though there's not been a formal charging document, appear to be fraudulent use of credit card, a felony fraudulent use of credit card, and felony false ID or possession of an ID of another person without consent. 2 felonies. The date on that new law felony charge indicates a fact pattern alleged of around March 9th. The charge that we're here on the bond motion, 23 CF 438, we had an arrest of February 21st, 2023. So maybe about 20 or so days before the credit card allegations.
So you're saying,
I
say that again. Well,
yes,
what's the case number in 1228?
1228.
What year is that?
That was 2023. Allegedly, an incident happened at a Walmart involving a credit card.
At what time?
March 9, 2023.
Okay.
And the arrest that led to the original case, 23 CF 438, my understanding is that arrest was on or about February 21, 2023. So that's I think about 16 days before the March 9 incident, if I'm calculating correctly.
Okay.
And I'm not, I do want to make sure I emphasize what I think is hopefully most salient in terms of his argument to get bond, is that he does have 2 children, 5 and 3, who really need him to be working and supporting them. Do you want to add anything? You work at Truth Plumbing and Gas. Can you put under oath to say anything he wants to say about his family situation?
Sure.
Work
If you raise your right hand, do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Without discussing the facts of the case, what would you like the judge to know about why you are respectfully requesting the opportunity to get out on a bond in 23 CF 438?
I'm one of the sole providers of my family. I take care of my 2 kids and my fiance kind of when she's around. She's got a lot going on. I live at my dad's house with my father, help him out. He fell not too long ago, broke his collarbone, some medication.
Where do the children reside?
With me.
You're the primary caregiver for the children?
Yes. They're with my father right now.
Yeah.
My little brother just passed away 2 days before I came here. I wasn't able to make his memorial. I'm just trying to get back out and take care of things.
Your Honor,
I did have a bond on that before, but it got revoked when they arrested me for the.
What was the earlier bond?
It was $4,000, $300 to get out on the possession charge, and it got revoked when I got the resist arrest.
Your Honor, if I could clarify, I think it was $3,500 cash or professional, based on my record of first appearance.
And that's on which case?
That was on 23 CF 438. It looks like he got a cash or professional bond on that case the day after he was arrested on February 22nd, 2023.
And then 23 CF 1228, what was the, I know, what was the bond on that?
That's a total of $4,000 cash and professional between counts 1 and 2. 2 felony charges, a total of $4,000 cash and professional.
What's the state's position?
Your Honor, the state's position is that Mr. Brown, while he was out on bond for possession of controlled substance and possession of paraphernalia, committed credit card fraud and identification fraud and resisting arrest without violence, and that his bond should remain revoked. However, if the court is sympathetic to Mr. Brown's plight, what the state would request is GPS monitor pretrial services and manual analysis. If Mr. Brown is serious about taking care of his family, he will be serious about not abusing drugs and staying where he needs to be. So that's the state's position.
Your Honor, I don't think he'd have any problem with that. Yeah, I would request that the GPS be at the lowest permissible rate if the court was willing to consider allowing it. Thank you.
Okay. Court will reestablish cash or professional bond as stated. So the 1228 case would be total of $4,000 cash or professional, and the 438, the original bond was $3,500 cash or professional. Court will reinstate those with the additional pretrial services that would include random UAs and a GPS monitor. Allow you to get back to work and try and do it.
Your Honor, can the GPS be at the lowest permissible rate?
Yes.
Thank you.
Thank you very much, Your Honor. I'll submit an order.
Okay.
I didn't have the 1228 on today's docket.
It was not, we were just, there's no changes in 1228. The court, we were just clarifying the total.
Okay.
Thank you, Your Honor. Sorry for the confusion. Eric Curtis? Your Honor, Eric E. Curtis is before the court in 22 CF 1373. He is signing the VOP agreement we worked out with the state that I've previously been over with him. And this is on misdemeanors, Your Honor, so there will not be a score sheet.
Okay.
If I may approach, Your Honor.
You may.
Your Honor, under this VOP agreement, Mr. Eric E. Curtis in 22 CF 1373 will be admitting violation. He will be adjudicated guilty, and he previously had a withhold, is my understanding. So this will be the first conviction of anything, but it will be on misdemeanors. Yes, ma'am. Revoke or terminate existing supervision, 60 days jail with credit for all time served, $100 VOP fee, $150 public defender fees, outstanding monetary obligations to collection 6 months after release.
Okay, Mr. Kurtz, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Is the state in agreement?
This is the state's agreement, Your Honor.
Thank you. Mr. Curtis, you heard your attorney state the terms of your plea agreement. And
Yes,
I see
sir.
those same terms are written in the written plea agreement that you have signed. Did you read this plea agreement closely?
Yes, sir, I did.
And did you go over it with your attorney, make sure you had all your legal questions answered about
Yes, sir.
the agreement?
Yes, sir.
You understand you're waiving the right to go to a trial and some other valuable rights? Final resolution of your case here today.
Yes, sir.
And was this entered into freely and voluntarily? Nobody twisted your arm to get you to enter into this?
Yes, sir.
Okay. Based upon that, the court will accept your plea agreement. There'll be an adjudication of guilt. Court will revoke and terminate existing supervision. Sentence you to 60 days in the county jail. You will get credit for all time served. You've got the $100 VOP and the $150 PD fee. You've got to pay those within 6 months after you get out, or it'll go to collection.
Yes, sir.
Okay, any questions? You do have 30 days, even though you're just agreeing to this, you got 30 days to appeal.
Yes, sir.
Okay, thank you.
Yes, sir. Thank you. Thank you, sir.
Is this Jared Dawson? Your Honor, Steve Medina with Jared L. Dawson Jr., 23 CF 1094 and 23 CF 212. At this time, I'm respectfully requesting if we could set him aside. He had wanted to see if we could do a Barsabed-Keaton deal. The state is working with us, and I think we can get a global resolution of his cases with Barsabed-Keaton, which give him the treatment that he needs. Keaton just today accepted him. So is there any way we could hold him over to either for another 30 minutes or so, or maybe even to the afternoon if the state has to do an information in the newest case, Your Honor, so it may take a little while.
Would that resolve the warrant that he has?
I'm not familiar with the warrant. Is it in relating to one of these two cases or no?
I'm not sure. I know that it's in the back. Maybe Madam Clerk has something on it.
On Mr. Dawson?
Yeah.
Yes.
Do you still show anything in the system? I know that booking had a warrant for him.
Okay, it's not flashing on this one, so let me run his name to see if it's an investigative or if it's a DOP.
We do have, Madam Clerk, I don't know if it's the same thing, but we do have in 23 CF 212 is a VOP, I think.
Yes, sir, it's on today's docket because he was arrested. Can you check to see if it's an investigative form out of the SA? I don't have anything, and I have cases on him, Your Honor, but I do
You
not.
know, that warrant on Jared Dawson, can you tell me what that was for?
It might have been just arrest on the VOP, but since he's in
I
jail.
show that he went to first appearance on 5/15 for this case, and for a new charge of 23 CF 1094.
Probable cause for petty theft? New charge.
Well, I think
Yeah, that's new charge.
is it a misdemeanor?
Sounds like it. Petty theft.
Okay, Your Honor, what we can try to do is, I can try to get that misdemeanor case information to the state and see if we can wrap that in. It doesn't sound like that's probably gonna be a huge issue. Do you think we can bring him back, this afternoon? Would that give the state enough time?
He'd have to be processed on the warrant, the case would have to be.
So he's gonna have to go back to jail.
He would have to be processed on it. This does not, however, for the record, change the state's offer of drug treatment because we believe all of these cases would be related to drug.
And because it's a probable cause warrant, you don't have a case number, it's got to get served and processed.
Right.
So what do we need to do to that procedurally?
I would say procedurally, Your Honor, number one is in 23 CF 212, we can go ahead and enter a denial. And the 23 CF 1094, we could waive arraignment this afternoon, enter a plea of not guilty. if the court will permit it, he could be put on Monday's docket, even though he's probably in another pretrial period. I'm not sure. I think he actually would probably be appropriate for Monday, docket day, and it would probably clear, continue, resolve everything then, hopefully.
I think so.
Yeah,
I will
be
be
good.
here on Monday, and as long as we can get a case number for the misdemeanor case, we can add it to the plea agreement and get him moving.
Well, you're talking about the misdemeanor, the new law charge?
The new law,
The
once
new
it's
law charge
processed.
apparently probably cause not, doesn't have a number.
Ah.
That's why it needs to be processed. That's what
Yes.
the clerk just informed us.
Yes, but once that gets processed, we should be able to add it to
We
the
still
plea
can get
agreement.
it done on Monday.
Yeah.
Yeah,
Thank
we'll
you.
add them here.
Monday, hopefully by
It
then.
will be all three cases we'll deal with on Monday.
Yes, Your Honor.
Hopefully.
Thank you.
Okay. Docket day 6/19, 9 a.m.
Beautiful. Thank you, Your Honor.
Thank you.
John, you Your Honor, John J. Ewing before the court in 22 CF 2460. It's a very similar situation in terms of my position to another defendant we had, Mr. Blunt, a few minutes ago. With respect to the Brady motion, I'm going to withdraw that motion at this time. With respect to his motion to dismiss, the state is going to be providing a written response and will be a narrowing of the issues to some extent. And there's also been I did get an FDLE report on one of the charges. I would ask to return Mr. Ewing on docket day for plea or continue with a hopeful global resolution for him at that time.
That is the state's understanding as well, Your Honor. We have no objection to proceeding in that manner.
Very good. Court will just go ahead and continue all of these until docket day, which is Monday, 6/19 at 9 a.m.
And that's plea or continue, Your Honor.
Plea or continue.
Thank you, Your Honor.
And you want to do your honor?
Your Honor, may I call up my applicant?
Sure. Which one is that?
I have Mr. Jutras and I have Mrs. Snowden.
Give me again.
Derek Jutras.
Jutras. You want to do that one first?
Sure, Your Honor, that'll be all right. 22 CF 520. This is in the negotiated plea on the VOP, Your Honor. Reviewing the parties contemplates that it is the asking the court to reinstate and modify the probation to include completion of the Keaton program and any recommended aftercare. $100 VOP fee, $150 cost defense. All of the terms and conditions will be reimposed. The only request from the defense, the state is all right with the Keaton component not being bars to bed, so there's no reason for him to be incarcerated. Mr. Jutras has made the request that he be allowed to report to Keaton on July 7th. The state and the court will be okay with that date. If we continue to be monitored probation in the meantime.
Why? Is he approved for Keaton?
He is, Your Honor.
So why are we waiting?
It was at my client's request, Your
I
Honor.
know. Tell me why.
And the state's opposed to that, by the way. That wasn't discussed. So if he's been approved to Keaton, he needs to check in.
The reasoning for the request, Your Honor, from my client is he's trying to give his work plenty of notice so the job will potentially still be available to him when he's released from Keaton. And then the other reason is that he has family coming in on the 4th of July and he was hoping that he could see them before he was placed into the inpatient program. But at the end of the day, Keaton's ready to receive him, as far as I know, Your Honor.
Get it done.
So when we
like the president. So you want it, if they're ready, if Keaton's ready, let's report, let's get to Keaton. I mean, if you need a day or so to kind of make sure and talk with your boss, and I'm very sensitive to the whole work situation. Not sensitive to you having a nice 4th of July either with your family, but this is more important. If you want your family to you want to do what's good for your family, then get yourself right.
So from the court's perspective, when does he need to report?
How long do you need to talk to your boss? Tomorrow? Next day?
I mean, typically, from my understanding, they require at least 6 weeks notice.
Your work?
My job, yes.
Where are you working?
Gelato. GS Geronimo. Where,
Are they aware of what's going on with you?
yes,
They need to make an accommodation. Look, they're dying for people. If you're a good employee, they'll get you back. And if you don't, you can find another job in gelatos. You know, if that's where you're working, you can find another job. There's jobs out there. I'm not trying to be harsh, but the reason why, honestly, I don't want to give you an opportunity to make a mistake. I want you to be successful.
oh, absolutely.
I'm saying, I'm not trying to be like hard ass.
Yes, sir.
That's why you need to know I'm doing it, because I want you to be successful. The best way to be successful is to work this program. And even that's gonna take a lot. Even that's, you know, it's not like all this stuff ain't automatic. You appear and everything works out well after keeping.
Yes, sir.
So I just gotta start right here. If you care about your family,
Yes.
then, you know, this is day by day. Anyway, I'm not trying to preach it.
Could, how about, is a week okay? 1 week?
How about Monday?
Okay.
It's understood, Your Honor.
Monday, 5 o'clock?
I'm gonna write that on the plea, Your Honor.
Monday, 5 o'clock with the objection of the state.
June 19th.
Okay? It's June 19th for the record there tomorrow.
I have it here, Your Honor. This will be the defendant, reflected on the plea agreement, defendant to report 6/19 by 5 p.m.
Okay.
And with that, Your Honor, I'll pause and give.
Remain under pretrial services in the interim?
I will continue.
The honor pretrial?
Probation, I'm sorry, by probation, would you honor, he's going to be reinstated, so we'll continue.
Okay, so.
I'll pause and give Mr. Jutras an opportunity to sign.
Your Honor, while he signs, the state would point out that this is already a downward departure, and he scores 52.2 points. And I will get the court a score sheet.
No objection to score sheet.
What's the basis for the downward departure?
Negotiated plea, Your Honor.
Mr. Jutras?
Yes, sir.
Like I said, I know it's not easy. Take advantage of this.
Yes, sir.
They're pushing hard for, they're already downward, you're already scoring for DOC. So, you know, get this, make this stick.
Sure.
Okay, sir, just need to ask you a couple of questions for me for the record. Would you raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So, we've been talking a little bit about some of the final details of this plea agreement, but the plea agreement that was explained by the state, that was addressed or stated by your attorney, is that your understanding what the plea agreement is? I see it's also contained in the written plea agreement, although it's somewhat hard to read.
Yes, sir.
Okay, is that it? This is your plea agreement?
Yes, sir.
Okay, and you understand that by entering this plea agreement, you're waiving the right to go to a trial?
Yes, sir.
It's going to be a final adjudication of this violation of probation. You understand that?
Yes, sir.
Okay. So based upon that testimony, the court will reinstate and modify. So is he being placed back on probation with the condition that he attend Keaton? Is that technically what we're doing?
That's correct.
Very good. And you've got fees and costs that, how long does he have to pay these fees and costs?
To the term of probation, Your Honor.
The term of probation. And the defendant will report to Keaton 6/19, 5 o'clock. Okay. Good luck.
Thank you.
Next will be Ms. Holly Snowden, Your Honor. Snowden. This is 19 CF 1894. This is going to be a negotiated plea under VOP. The agreement of the parties contemplates that we'll be asking the court to accept her admission, revoke and terminate with probation. I did abbreviate that as RT on the plea agreement, Your Honor. Impose a new 2-year probationary period with road to recovery completion as a condition. $100 VOP fee, $150 cost of defense. All misdemeanor counts will be time served. She does have a bed waiting on her. We are asking her to be allowed to report road to recovery on Monday, Your Honor.
Why?
That's when they have the bed available, is my understanding.
So Monday's when they will. Okay, very good. Is that the state's agreement?
That is the state's agreement. This is not a downward departure, and I will supply the court with a score sheet.
Thank you.
May I approach, Your Honor?
You may. Thank you.
How long will you term this for?
2 years. Okay, Ms. Snowden,
Yes, Your Honor.
will you please raise your right hand and ask you a few questions? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, to my understanding.
So, you heard your attorney state the terms of your plea agreement, which is also contained in the plea agreement form that you just signed. First of all, did you read this agreement closely?
Yes, Your Honor, to my
You agree.
understanding.
And did you go over it in detail with your attorney to make sure you had all your legal questions answered regarding this plea agreement?
Yes, Your Honor.
Because you're waiving some valuable legal rights, right? Go to a hearing and some other things. There are valuable rights. Before you waive them, I want to make sure you're doing it freely and voluntarily. You understand that?
Yes, Your Honor.
Do you believe it's in your best interest to enter into this?
Yes, I do.
Very good. Based upon that, the court will accept your plea agreement. There'll be a revoke and terminate. Are we adjudicating on this?
I believe she was previously adjudicated, Your Honor.
Very good. The court's going to sentence you to a new term of 2 years probation. As a condition of that probation, you'll participate in the road to recovery, not only participate, but complete road to recovery, substance abuse inpatient program. And that is a condition of your probation. You've got some fees and costs. All misdemeanor counts on this, which is the possession of paraphernalia
And driving license
and
suspended.
driving unsuspended, are both misdemeanors. You'll get credit for time served. Those will be done with. So you're essentially serving your probation on the possession of a controlled substance. Do you have a question?
I do, my driver's license was never suspended.
My expectation is that that was a plea of convenience on the
Yeah.
front end or something to
Yeah,
that
I've
effect.
heard
It was
that.
previously adjudicated when I received the case on that secondary misdemeanor. I can't speak to that.
I'm sorry, I don't understand the point.
I just
I'm
never,
confused.
my driver's license. I was
She's
just-
raising
Can I
a
say something
factual
about
issue.
driver's license?
It's just the fact that I never heard of my driver's license being suspended.
I didn't say anything about
Oh.
driver's license.
The
Did I miss?
It
Did I
came,
miss?
Oh.
no, you did not mispronounce, Your Honor, on the record, on the clerk's side, she had pled to a second degree misdemeanor driving license suspended as part of the initial plea.
Oh.
And she is saying that she never had a suspended license. I'm advising the court and Ms. Snowden.
Oh,
That's a
that's
factual
right.
issue on the underlying case.
Oh,
We're
well.
way past that to an extent. but-
Yeah, that's already, okay. That's already gone, said and done and signed.
Correct.
Okay, well,
Yeah, I mean, you never had driver's license suspended, you shouldn't have been charged for driving unsuspended, but
okay.
that was prior
Right.
to this time, you've gotten credit for time served, so that goes away.
Right, okay,
But, okay.
okay.
So, 2 years, road to recovery, that's the key part of it.
Yes.
Do you have any questions concerning any of this?
No, Your Honor.
Okay. Good luck.
Thank you.
Take one day at a time. It's not an easy program.
I understand that.
Good luck.
Thank you.
Robert Willis. Ryan Markle, Mr. Willis, Your Honor. We had set him back, thinking that we would be able to resolve this matter via negotiated plea this afternoon. The state has raised a concern that they wanted to reach out to the alleged victim before finalizing that offer. So in order to afford them an opportunity to do that, I don't know if they can get that done before the afternoon docket today, and maybe we can still get that to be done. If not, I'd be asking for 6/22.
I think I can get it done by 6:20 or.
Okay.
Well, I can do it today.
So do we have a miscellaneous on June 20?
That's, is it 20 or 22 for Your Honor?
I think the miscellaneous is on the 20th.
I got this here, June 20. That's the day after our docket day.
Yes, sir. That docket went out this morning.
Okay.
Let's see, we have 32.
We can add this for.
I anticipate this will be a brief plea, Your Honor. The state just needs to.
So we'll continue this to June 20th at 9 a.m. Hopefully for plea.
Thank you, Your Honor.
Okay, thank you. Okay. What else you got?
I have, still have Ms. Ursula Kirkland, anticipating
Kirkland?
plea.
You have, Frank, you still have that, you got right, it was supposed to be that, Ms. Harper, I think. Loretta Harper?
Bill Kirkland?
Oh, Kirkland.
Ursula Kirkland.
No, I didn't put in a denial for this case, so I'm just going to put it on the 20th for Mr. Webster.
So enter a denial.
We can enter a denial, but we anticipate plea in that matter. Ms. Kirkland, Your Honor, may I have a moment? Any questions? Okay. This is Ms. Ursula Kirkland, Your Honor, 22 CF 2682. She's asserted a desire to accept the state's offer today, which contemplates that we'll be asking the court to revoke and terminate the supervision, sentence Ms. Kirkland to 12.1 months DOC with credit for all time served, $100 BOP fee, $150 cost of defense, all financials to reduce to lien in 1 year after her release. I'll pause and give Ms. Kirkland an opportunity to sign.
Your Honor, while she is signing, I would say that this is not a downward departure. She scores 39 points on the technical violation. I'll get you the score sheet.
Very good.
Thank you.
Then it's okay with the score sheet?
Yes, Your Honor. No. May I approach, Your Honor?
You may.
We're going to need minutes. This was a prior withhold.
In this matter? May I have a moment, Your Honor? Folks, indicating this is not private adjudication. I just want to make sure that Ms. Kirkland's okay with that.
Is that going to reflect it?
No, it's going to be the same. Just want to make sure you're good.
Yeah, I'm okay.
May I approach, Your Honor?
You may. Thank you.
Yeah.
Ms. Kirkland, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes.
Okay. So you heard your attorney state the terms of your plea agreement, the core of which, the main thing is the revoke and terminate probation, finish with that, and you'll be sentenced to 12.1 months DOC. You will get credit for all time served. And then there's fees and costs that will go to collections. How long? Can't read your writing.
1 year after release is
1 year. Okay. 1 year after the release. If you can't pay it within that, it'll go to collections. Okay? Is that your understanding of the
Yes.
agreement? And I see you signed this plea agreement. Did you read this?
Yes, sir.
And you went over it with your attorney in detail, got all your legal questions answered?
Yes, sir.
You understand what what, that you're waiving the right to go to a trial, and this will be a final adjudication of your case. You understand that?
Yes, sir.
Very good. Based upon that, the court will accept your plea, court will revoke and terminate supervision, sentence you to 12.1 months, Department of Corrections, with credit for all time served. Fees and costs, you'll have standard fees and costs payable 1 year after your release, or it goes to cost. Thank you. Good luck.
I just made this curtain.
Is that all you got for tomorrow?
I think I may have a few others, Your Honor. I'll let the clerk call anything that hasn't been called. Ryan Morrow from Mr. Bailey. This is a matter that. Where?
Michael Allen Bailey. He's out of custody.
No information, Ryan Morrow from Mr. Bailey, no information to report on what's going on with Mr. Bailey today. The only thing I can say is that we have received notice from the clerk that he was not qualified for the public defender for various financial reasons, so we had filed a motion to be relieved based on that. The court can rule on that, I suppose, when it's brought before the court. I don't think it's appropriate to have it now without him here, but.
He has an order revoking bonds.
So he's already got an order revoking bonds?
Yes, sir.
Okay,
Say we asked for a vacation.
court will issue no bond cases.
I believe that is all that.
What's that?
I believe that is my last one.
Okay, very good. Now what? Okay. Go ahead. So, Mr. Medina?
Sir, yes, sir.
I think you're up.
Do I have anything more on the calendar?
Well, let me see. I've got
afternoon stuff.
I've got Benoit.
I believe that's Mr. Morrow's case.
That was mine, Your Honor. We passed him to 718.
Did we? I remember we handled him yesterday.
We handled him today?
Yesterday, or?
Was it today?
I was before the court
Was it
yesterday.
today?
Yes, sir. We were talking about how to properly pronounce his name.
Benoit?
I was saying Benoit. I was putting.
According to them, I'm trying to pronounce the name properly. When did he,
Actually, this person with the name appeared this morning and entered a denial and put on July 18th.
Yes.
That's there, okay, somehow I can get my.
Says put Mr. Morrow through his assistant under the bus.
Sure did.
Okay, so. Very good. So, there you go. Let me see if, Mr. Medina, if we have anything else?
Yes, sir.
On mine?
I'm not aware of any, Your Honor.
But just making sure.
Yes, thank you.
Okay. We're good. Okay, so we'll reconvene at